Hi friends from around the world. Let's talk about one of the most famous cases, patent cases from the European Court of Justice. This is the ZTE Huawei case from 2015. It is a very complicated case, but I will make it very easy for you to understand. It is a balancing act between competition law on one hand, IP law on the other, and a third pillar would be the judicial protection, all of which has its merits, its own merits. Now, if it has all its own merits, it is the aim to find the right balancing act so that all the interests of the actors, which have its own merits, are well guarded. So what is it about? Let me just recall a bit about SEP, Standard Essential Patents. You all know that. If not, please go back to one of the videos on my patents, the free educational videos, and you find it. Standard essential patents, mainly in the telecommunication industry, are very important in order to assure interoperability of the different systems, the different hardware, the different software, etc. So there are standards which is necessary in order to make the scale of economy, and all parties have a certain interest in the existence of standard essential patents. Naturally, those who have standard essential patents, well, they have a kind of favored status, but on the other hand, there are people out there saying, well, if it is standard essential patents, I am too much in this triangle, and I'm bound by my freedom of marketing, freedom of contracting the license I want, or if I don't want to give any license, I don't want. So they are more in the camp of saying, well, I don't want to have a standard essential patent. So the standard essential patents imply that those holders of standard essential patents, they have to commit to give license out to other parties. And on top of it, it must be under FRAND conditions, F-R-A-N-D, FRAND, meaning that it must be fair, reasonable, and non-discriminatory. This is all more or less clear. And it was by the time the court decision has been taken in 2015. Curiously enough, there were two Chinese companies. ZTE is one of the biggest Chinese telecommunication company, and Huawei as well is a multinational giant of Chinese origin in Shenzhen, where I was already. A very nice headquarters with a train, an ancient train going around. Well, so interesting enough, they were in Germany and had some problems. The problem started, so to say, in Germany, where ZTE was using patents of Huawei. And Huawei sued ZTE over an injunction with damages, etc. So the normal portfolio of damages, of claims which were done against the infringer. So that came to in Düsseldorf, which is a town in Germany, which came to the court, and the court, well, what does the court consider? Well, there was a kind of German tradition which came long ago from 2009 in the Comvic case, where the German case law tend to favor the SEP holder and not allowing, so to say, what would be the injunction, and injunction would not in principle be against competition law. So the convict that came from a case, a German case, where Philips was involved with its CD-ROM standard, and Philips sued the infringer, and the injunction was allowed under that circumstances, and that came up with a convict jurisprudence which was favored by the Düsseldorf court. Now, at the same time, where the Düsseldorf court was about to decide, there was a Motorola case from the Commission on the competition part, whether Motorola was by making an injunctions against a competitor, against an infringer, was against, so it was Motorola again, was a SEP holder, right? And was with the injunction infringing on competition law, so to say, to abusing its dominant position in that sense. And the Commission was rather in favor of the injunction being an abuse of dominant position. So there was a bit a difference between the German position and the European Commission. Now you have to know that competition law is one of the most important competencies which has been transferred to the European Union from the member states. Now you see the picture a bit. We have a German law, we have a competition side where the German law was not, German court was not sure whether competition enters into the mix, and they have to apply Article 102 of the Treaty of the European Union, which rules about the dominant position in competition and does not allow an abuse of the dominant position. What did they do? Yes, 267, they refer to the Court of Justice with a questioning, with submitting questions on the interpretation. Now, it was about this triangle and about the abuse of dominant position by suing an infringer through an injunction. An injunction is naturally, is allowed. Is in all member states. It has been allowed as a part of a judicial protection, which is part of the Fundamental Rights Charter. So you can have an injunction, but under which conditions? Well, there must be, on one hand, so they took a middle path, so to say, between the German position and the Commission's position. And it is all about common sense. So it is very complicated, but it is about common sense. We have a SEP holder, a standard essential patents holder, who has committed, due to its standard essential patent, committed to license out to any willing party on FRAND terms, right? And we have an infringer. So if the infringer, and that is the position the court took, if we have an infringer who is willing to license to an implementer, so to say, infringer implementer, who is willing to license from the SEP holder, then there should be a kind of negotiation implemented among the two parties in good faith. That is the general principle. It cannot be that if the one is willing and the SEP holder is messing around and inclusively in suing the implementer with an injunction, then this cannot be. That would be rather an abuse of the dominant position. Or on the other hand, if a implementer is saying, well, I want to license from you, SEP holder, but on the other hand, if it gets an offer which responds broadly on FRAND terms, well, it is messing around or saying, well, I cannot decide now, and I make a counter offer which is ridiculous or so, then messing around, then it would be not a abuse of dominant power if the SEP holder makes an injunction or sues for an injunction, seeks an injunction against the implementer. You see the game? So what happened here is that there is one thing I want to mention. The Attorney General, I talked about the Attorney General in other videos briefly. The Attorney General in important cases is a figure who objectively and previous to a court ruling is giving its guidance on the case to the court to observe, and more often than not, the court follows the Attorney General's opinion and is published on the website of the European Court of Justice. But my point is, the Attorney General's opinion is easier to read than the judgment. So it is rather than an essay on legal issues, but it is easier to read. So in this case, the Attorney General opinion, Wathelet is the name, is easy to read, and it could be an idea for you to follow it. Now, what the important thing is here, that the court comes up with guidelines, concrete guidelines of what the parties have to do in order to engage in fair and common sense negotiation for a FRAND license. And here they are on the screen. What you have is that the implementer, the SEP holder has to advise the implementer that there's an infringement, and the implementer then has to say, so to say, that he is willing to license from the SEP holder the SEP on FRAND terms, and then it is on the SEP holder to make clear what is his offer on and what he does understand on FRAND terms, and it must be more or less within a certain margin of FRAND terms, and so on and so on. You may read it in full on but it is rather common sense what has to do. So if you engage in any negotiation in good faith, then you will come to these guidelines without even knowing them. What is the importance of that case? Well, harmonization among European countries. That is an important issue. It was not before. I told you about the German position, but there were other countries where they have developed their own style of dealing with that case. So it was a bit dispar among the different countries, and now we have a common approach. It is only a first step. So the guidance that is not clear what is fair and what is reasonable and what is non-discriminatory, that is a bit more clearer. But when it comes to the royalties, to the license fee, well, you you don't know exactly how to deal with it, and the settlement in court is the preferred solution for everybody, because if you want to have a forensic expert to go into it, it will go to high figures. They are more expensive than the lawyers in London. So one of the important cases you have to know, it is complicated in its overall structure, and it comes competition law comes into the mix, but I made it in a sense for you, I think, quite straightforward.